My people, it don't happen. Hey, Peter Obi and Atiku Abubakar, they say they are going to challenge the court's judgments that is unacceptable. They say they can never accept such because they have every evidence that the vote was So for that simple reason, they will go to Supreme Court to prove that they have rights. Una know as I did do one, they like make I they give una the full video. But before then, this thing una they see so, it will put everlasting mark for Nigeria records. It will not be deleted by anybody. This is going to be a sign before anybody want to do anything. You will think of this our days and they will use the sense.
Register to vote. Bola Tinubu, the winner of the election, garnered just 8.79 million votes, the fewest of any president since the return to democracy in 1999. Joining us now on The Morning Show. Joining us now on The Morning Show as we review the verdict of the Presidential Election Petition Tribunal is Norris Quakers, a senior advocate of Nigeria. Good morning, Norris Quakers, and thank you very much for joining us.
It's indeed my pleasure. Good morning, Dr. Abati. Good morning, Rufai. Good morning, Ayo.
Well, quickly, there's no need for any long introduction. We've been on this subject since Wednesday, and you're familiar with the details. But first, what are your observations about the reasoning behind the conclusions arrived at by the Supreme Court and the reactions since the judgment was delivered, particularly from the opposition parties, Labour and the PDP, who now insist that they are heading for the Supreme Court, as is their right to do?
Well, incidentally, to be candid with you, some of us are not surprised at the outcome of the election, the tribunal, the judgment of the tribunal. Nothing new has been said. Law reports are replete with a lot of the issues that were articulated by their lordships. Dr. Abati, you're a lawyer of considerable length of years or number of years in the practice of this profession. So you basically also know that pleadings determine cases in court. And therefore, the outcome of this decision is actually a reflection, without necessarily indicting the lawyers who are saddled with the responsibility. A burden is actually placed on a petitioner when proceeding to court to advance the position of your client. More particularly is the provisions of the Electoral Act and also the 1999 Constitution. As you proceed to court, you're meant to have front-loaded all your documents and things that you're going to rely on. You must put forward a credible case to sway the court in your favor. I recall that when the Supreme Court decided the Oyetola and the Adeleke case, it set the ground rule of things to also look out for. Now, before then, there have been other cases. Recall that I think it was in 1979, this issue of interpretation of the provisions of the Constitution as regards a president winning 2/3 of, I think it was 19 states at that time, Chief Richard Akinjide and also, I think, Chief Ibrahim Adesoya were the two leading counsel at that particular time. And when the decision was given, I recall that both counsel were interviewed. And I recall that Akinjide, when he was asked the question of blessed memory, and incidentally both of them are late now, he said he does not see the need to go on appeal. Now, there's a political side to law, and there's also the law itself. Now, as far as he was concerned, it was a decision that could not really be appealed against. But he now went further in saying that if they choose to go on appeal, it's their right, they have money to waste. But the late Chief Abraham Adesanya did say that they were going on appeals. I mean, it's the constitutional right of anyone who feels aggrieved to go on appeal. But if you x-ray the decision, as I have done, because we listened to it and I also took notes, it will be a bit watertight to want to go on appeal to challenge it. So for me, it's a very good decision. It's quite laudable. It's also an eye-opener to a lot of us who will be going to court on a number of issues. Like my boss will say, you don't go to court if you do not have a watertight pleadings. You must ensure that your pleadings are really, really tight. What do we mean by that? Your facts and your law must be solid. It must be rock solid before you can access the court and know what you're going to get out of the court with. So those are my own thoughts.
All right. Well, thank you, Mr. Quakers. And for the benefit of our viewers who are not legal minds like yourselves or the lawyers who understand the law of evidence and the likes, I'd like you to break it down for us, because you've said that you're satisfied, at least based on what you've heard, because we don't have the certified true copy of the judgment yet. At least based on what you've heard so far, you're satisfied with the judgment. But in line with what the Labour Party has said, that it doesn't reflect the will of the people, and certain reactions that have come out following that judgment, you know, some people feeling aggrieved. Yes, there's some quarters where there's rejoicing and people agreeing with the judgment. But I want you to share with us, because it's often said that law, when it comes to legal matters, it's not about the feelings of people. It's not about what people see, it's the burden of proof. Can you break that down for us, especially for those who are watching, who are not lawyers and are aghast at the outcome of the ruling?
Thank you so much for that question. First, let's look at it this way. What were the issues that were placed before the courts? Essentially, part of it was that the second respondent, that's Bola Ahmed Tinubu, did not win the election based on the majority of lawful vote cast. Now, what is a petitioner in that wise expected to put forward? You're meant to put forward evidence to show that indeed this particular respondent did not get the number of votes that is needed. Now, but the question is, was that done? The answer to that is no, because the court didn't see that credible evidence. Two, you're saying that the sum of $460,000 were forfeited to the state, and therefore it is an indictment. And so for that reason, he must be disqualified. Now, many years ago, Alhaji Atiku Abubakar, who is also a petitioner in his own right, he went to court when there was an attempt to bar him from seeking elective office on the grounds that he had been indicted by the federal government. Because if you recall, the then president, Chief Olusegun Obasanjo, set up an administrative panel of inquiry that came up with a white paper to bar him from seeking elective office. He went to court, challenged that the outcome of the administrative panel, and the court said for it to work, for that indictment to work, it must be a conviction. So that issue has already been determined by the court. So therefore, if you're saying a man was made to forfeit $460,000 and therefore it's an issue of dishonesty, question is, was it a conviction? Now, if it was adjudged in a foreign jurisdiction, right, we have a system in place. If you bring it in, you're meant to also register it to make it effective and applicable to the Nigerian system. So in other words, it must now be within the Nigerian context a conviction. So having not done that, it cannot be sustained. Now, the other issue that was also raised was the issue of INEC not transmitting the results in record time. In other words, INEC not complying with the statute, the enabling statute, which is the Electoral Act. And so LP went to court on that. LP had gone to court at the Federal High Court, Abuja, Justice Nwite, my memory is not failing me, in an attempt to compel INEC to use judicial intervention to compel INEC to comply with the Electoral Act. And his lordship in his wisdom ruled that he does not see the need, and therefore that INEC cannot be compelled to perform its statutory duties, that the interpretation of the clear and unambiguous provisions of the Electoral Act gives it some discretionary right. And so for that reason, he threw out the case. Now, LP did not appeal that decision. LP came down again to Lagos and obtained a judgment from a federal high court in Lagos. And in the course of that, APC also went to court to get that decision set aside. So you now have a court of appeal decision also on that issue, confirming and aligning itself with the decision of the Federal High Court Justice Wite. Recall that part of what their lordship also addressed was also this issue, that it was like forum shopping. You had abandoned that you had attempted to obtain in the Federal High Court, Abuja, left that, came down to Lagos, got another order which was eventually set aside. So the court also held that this issue has already been litigated. So therefore, it is caught by what we call in law the doctrine of res judicata, amongst other things. So essentially what we're saying is that, look, there's nothing new that this tribunal has pronounced upon. All of these issues have been addressed one way or the other in a number of cases. A particular example, once you're meant to have front-loaded your processes, you cannot bring an application by way of even an amendment, because election petitions are time-barred, they're time-related, they're time-bound. You must file within 21 days. If you bring any other application outside of it, the tribunal will refuse it. And there are cases in that regard. There's so many cases in our law report. There's APC, Amarafa, and a number of other cases.
Okay.
So the question is, why would you take that step
Okay.
when you know that the law on this is very clear?
Okay.
Thank you.
Okay, Mr.
Yes.
Quakers, thanks for your deep illumination. Currently, you're a lawyer of, great repute, great standing. You're doing a lot of cases. Like currently, you're the one defending the APC in the Lagos case, and you've been doing all of these filings and all of that. Can you, throw more clarity on the Evidence Act? How should they have filed?
Let me understand you. The Evidence Act, in terms of how should they have filed?
Yes.
Now,
So
the Evidence Act is also very...
Yeah, go ahead, sir. Yes, sir. How should they have filed? Yeah, just throw more clarity on
Okay,
that.
the Evidence